Daily list, daily will be item 7. Next.
Yes.
I'd like to mention item number 18, 19, and 23 analogous matters. Yep. Maybe password, but the tailor will come up after 2 weeks.
You have informed the other side.
Yes, Lordship, with the consent of other side.
What is your name?
JH, Lordship.
J. Heard Mr. J. H. Laskar, learned counsel for the petitioner. Who prays? Why are you praying for it, Judge?
Lordship, actually, what happened in this case, learned senior counsel, Mr. S. Dotto was supposed to appear to, but he is not available.
Who prays for an adjournment on the ground of personal difficulty of the conducting senior counsel for the petitioner. He submits that he has informed learned counsel for the other side regarding his prayer for adjournment, who does not have any objection to the same. Hence, the prayer is allowed. Let this matter be listed after 3 weeks on a date to be fixed by registry.
There is an interim order in
The
item.
interim order shall continue till next day.
Apply.
Yeah, please, Your Lordship. Your Lordship, I beg to mention item number 7 also. Real hearing matter, Lordship. Your Lordship, this matter may kindly taken on next week, Lordship.
Heard Miss M. R. Devi, learned counsel for the petitioner, who prays for an adjournment on the ground of personal difficulty. The prayer is allowed. Let this matter be listed 15th of June.
Order. Item 8.
This is an IA for suspension of sentence. The PP is
Who is for this state? PP9. Let PP come, we'll take it up. PP code call. On call. Call the next item, then
Item 9.
Lordship may kindly pass over the matter for the time.
pass over for the time.
Item 10. Item 10.
Next.
Item 11.
Repeat a lot. So this is IFO sentence.
PP would be required. Wait for some time.
Item 12.
Yes.
Please, Your Lordship. Lordship, this is for washing of FIR, Lordship. And TCR was called for, and TCR already been come, Lordship.
Has not come.
Come, Lordship, and earlier occasion I had seen, Lordship. But apparently, Lordship, the case is registered under section 6 of POCSO Act, Lordship. But I have gone through the TCR, Lordship. There is no any ingredients against the section 6, and 164 and 161 is there, Lordship. So kind of for a moment, Lordship, maybe.
Whether notice to respondent number 2 has been served.
Lordship, and not seen the office note, Lordship, but the step has been taken.
You have not taken any steps for issuance of notice.
Taken, Lordship.
You have not taken. When have you taken? You were directed to take steps.
Take a step.
You take fresh steps. Heard Mr. F. Hawk, learned counsel for the petitioner. On perusal of the office note dated 29/5/2026, it appears that the petitioner has not taken steps for issuance of notice upon respondent number 2, as was directed by this court. The petitioner is again asked to take steps for issuance of notice upon respondent number 2 in pursuant to the prevailing notification of the registry in this regard within 7 days from the date of this order, returnable on 26th June, list according.
Sorry, Lordship, I have one other submission, Lordship. In this case, Lordship, charge sheet already been late, Lordship. So I will submit the certified copy of the charge sheet with the additional affidavit. Because otherwise, Lordship, the section 6 will not come here.
No. First, you take steps. The
Better for getting the charge sheet, Lordship, in the court. Step will take, Lordship.
The petitioner, learned counsel for the petitioner also prays for filing an additional affidavit to take some additional pleas and bring some additional documents on record. The prayer is allowed.
Deeply obliged.
Yeah, this one, item 1.
PP form করেছেন? কোন?
May I please, Your Lordship?
Yes.
But by way of this petition, my lord, we are praying for like quashing of the proceeding. Petitioner, before your lordship, two petitioner, my lord, jointly preferred this petition, informal and accused lordship. Out of love affairs, my lord, relationship is there and subsequently separated from each other. And both parties are my lord, resuming their separate household also. So my lord, before your lordship, jointly preferred this petition with prayer of quashing, my lord.
376.
Yes, my lord.
Where is the law that joint prayer 376 can be quashed?
My lord, here our High Court, here is a my lord, for observation is there, lordship. May I refer this judgment, lordship?
Yes.
My lord, paragraph 8, lordship. May I read, my lord?
Yes.
The apex court in the case of so and so reported substance has held that when a compromise has been arrived at between the parties by which the parties have withdrawn all claims and allegations against each other, technicality should not be allowed to stand in the way in court.
This will not be applicable. In a 370, whether
My lord, here 376.
this Nikhil Merchant case was of a 376 case. Have you gone through?
No, that is not 376, but
The-
law regarding only of whether non-compoundable sections can be quashed or not. That is the law, lordship. In that law in Nikhil.
Or you show the any authority where a 376 case can be quashed on the basis of compromise.
Well, here this is the order.
No, it does not speak that 376 can be quashed.
Well, what text is 376, lordship. Text is 376.
No. You come prepared or I am dismissing this criminal petition.
After 2 weeks, lordship.
Heard Mr. K. Rahman, learned counsel for the petitioner. Also heard Mr. M.P. Goswami, learned additional public prosecutor. Learned counsel for the petitioner prays for some time to bring to place some authorities in support of his contention that even offense under section 376 of the Indian Penal Code can be quashed on the basis of a joint application made by the victim and the accused. The prayer is allowed. Let this matter be listed after 2 weeks on a date to be fixed.
Obliged.
Item 2,
Almost nothing of. Yes.
Please, your lordship, here in this case, lordship, the petitioner filed a revision petition lordship by challenging the order dated 5/3/2025, asked in lordship, criminal appeal number 15 of 24. Lordship, in this case, lordship, the lordship, the respondent lordship in this case failed to prove the alleged lordship advance payment of 6 lakhs lordship. And
What are the facts?
lordship, the lordship, the respondent lordship filed a complaint petition lordship under 138 of NIA before the lordship chief judicial magistrate and alleging that lordship on 16/11/2020 the petitioner
16/11,
16/11/2020 lordship
20.
2020. The petitioner approached him and asked for a loan of rupees 6 lakhs for business purpose. And promised that lordship he would repay the loan amount within a month. And lordship, the respondent number 2 lordship gave him loan loan to the petitioner on 23/11/2020. And on 22/12/2020, the petitioner handed him a check dated 22/12/2020 for repayment of the aforesaid loan, lordship. And the respondent number 2 lordship respondent number 2 lordship, the petitioner lordship issued a check lordship to the respondent number 2, and the respondent number 2
I'm giving you some time.
lordship,
Prepare.
lordship.
We'll take it up after something. You does not appear to be.
Lordship may fix the date, lordship, because I will file
against the fund.
No, you prepare, we'll take it up after.
I'll file the compilation lordship along with all relevant evidences lordship.
Heard Mr. Ayu Chaudhary, learned counsel for the petitioner. Also heard Mr. H.A. Ahmed, learned counsel for respondent number 2. Learned counsel for the petitioners prays for some time to make his submissions in this case, and also prays for filing his written gist of argument. The prayer is allowed. When?
Any date lordship.
23rd June. Let this matter be listed on 23rd.
If you
item 3 and 4,
Wait, please, your lordship. Your lordship, my senior is coming. Kindly take up this matter sometime.
After some time. Who is your senior? We'll take it up after some time. After some time later.
when 6 to the no suppose yes after some time.
In regard to 5 and 6, let me make my submissions. Last occasion, your lordship knew that they took time because.
Who will be coming?
Offer is coming.
Coming.
Yes, but he has got for us.
Last time it was.
Wait, let him come. Wait for some time.
My lord, my star has come. Item number 3.
For the wife.
He has come later.
Before the
Court.
You are for?
White lordship.
I am, my lord, in criminal petition number 1381 of 2025. Against, my lord,
And who is for item number 4? And who are you?
my lord, though I have been alleged in the complaint petition in a domestic violence case, I am the cousin's mother-in-law, brother-in-law.
Okay. You are ready?
My lord,
Domestic protection of women from domestic. Yes.
my lord,
Take-
I have challenged the proceeding along with the order taking cognizance. My lord, with your lordship's permission, I take your lordship to page number 39, annexure 8. এক নম্বরটা তো husband.
Yes.
My lord, here is the complaint petition under section 12 and 23(2) of the Domestic Violence Act. My lord, Shahanas Chaudhary is the wife victim. Number 1, I am not appearing, is the husband. I am appearing for 2, 3, 4, 5, 6. 6 is, my lord, the mother-in-law, and others are cousin and brother-in-law. As regards from petitioners, I can place it, my lord. 1, 2, 3, 4 are cousins. 1, 2, 3 are cousins. 4
Who's cousins?
cousins of the, my lord, husband.
Okay.
1, 2, 3 are the cousins. 4 is the brother-in-law of the victim, and 5 is the mother-in-law.
Six.
6. It is 6. Well, 6 is not there. Up to 5 is there.
Mariam Haq.
Mariam Haq is 5, mother-in-law.
And who is Rabia Sultana?
Rabia Sultana, relative, is the cousin, petitioner number 2.
Then the paper from where you are, at which you are looking complaint petition is different from what is in the court.
No, my lord,
In
because
there are 6
6.
respondents.
1 is, my lord, the husband.
Yes.
Well, he is appearing in item number 4. 6 is there in the complaint petition. So, my lord, I am appealing for 2, 3, 4, up to 6.
Okay.
1 is
6 is the mother-in-law.
mother. 1 is the husband who is appearing in item number 4.
Okay.
With due respect to my friend in item number 4, basically the allegations is against respondent number 1. But my lord, first submission that I want to make before your lordship is this: taking cognizance. My lord, your lordship may turn to page. My lord, the learned trial court has taken cognizance at page 54. Report is on this. May I read this slowly?
Yes.
CR is received on transfer, learned CGM C Bhumi. Now it appears from the complaint that this instant petition filed under section 12 of such and such acts amended up to such and such. Now the requirement of issuing notice to the accused as per section 223 of BNSS before taking cognizance of a complaint under section 210 of BNSS does not apply here. A better perspective to the aforesaid position can be understood by reproducing the relevant. This is the relevant provisions. I will not read, my lord. Now, my lord, next page. Provided that no cognizance of an offence shall be taken by the magistrate without giving the accused an opportunity of being heard. Now, a combined reading of both the provisions makes it clear that the provision to section 223 of BNSS of issuing a notice to the accused before taking cognizance of a complaint shall apply only when there is a corresponding offence under BNSS of IPC in the complaint. Therefore, in the light of above, I am the considered opinion the embargo of issuing notice to the accused before taking cognizance shall not apply to maintenance proceeding under section 144 PNL. It is tried to mention the maintenance proceeding is a quasi-civil nature such and such. My lord, my submission before Lordship is the recent judgment of Supreme Court has said earlier there were judgments where it says 482 is not applicable in a case of a domestic violence. Now it has held that no, you can file under the new provision and 482 both. It is applicable in a against abusing or process of the law in a complaint petition under Domestic Violence Act. If, my lord, my submission before Lordship is this, if the Supreme Court has held that 482 and the new provision is applicable in quashing of a complaint case under section 12 of the Domestic Violence Act, why not 223 will be applicable? Why not 223?
You make me understand why it should be applicable.
Because, my lord, the applicable because, my lord, when is a 482 is applied in a case of quashing of a complaint petition, my lord, this judgment is there.
That is not very reasonable submission.
But my submission is this, my lord.
Merely because 482 is applicable to 20.
482 cannot be applied in quashing of a complaint in a civil case. My lord, this is because the court held, though it is of a civil nature, but for abuse of the process of the court, 482, my lord, para 37 and 38, it is the recent judgment.
No, that is not the question before this court.
Whether the 223 is applicable.
That is the question.
But the question, my lord, that
this judgment is not
my lord, that I understand.
into written there. Well, there is no dispute that 482
is
applicable.
My lord, my other points are there, but this what I want to make because our domestic violence case comes through a provision of section 200. There should be a statement for the victim. On the basis, because the report of inquiry report is not required mandatory, statement of the victim, the procedure is not laid down in a domestic violence case. The procedure is earlier CRPC and now earlier the CRPC and now BNSS. The procedure is this one. Your Lordship may look into the procedure to be followed in a domestic violence case. Because ballot, the Protection of Women from Domestic Violence Act 2005, ballot does not provide any procedure to be followed, but that is only through a complaint petition under section 200 that idea, and now my lord different provision.
Okay. So your submission is that 223 of BNSS is applicable.
Applicable in also in case of a domestic violence case.
Why?
Because my lord, the procedure the learned trial court has to follow is through the BNSS or the CRPC, whatever it was. Now this case has come after the amendment is there. So if the trial court has to follow earlier 200, then 203, 204, everything should have been followed. We cannot jump over and say that section 200 statement of the victim is there. So I will not I will not take care of 223, which has been recently added in the new provision. (223) complaints to magistrate. Then, my lord, there itself it is there. Provided no cognizance of an offence shall be taken by the magistrate.
But he is not taking cognizance of any offence.
My lord, this provision of maintenance and giving some amount to the victim, that is only because there is some violence in case from the husband or other
But
persons.
whether he's taking cognizance of any offense.
Well, section 12 itself is my submission is section 12 itself, because there is
Section 12 is an
benefit, monetary benefit given to the wife victim.
No, you are not answering my query. My query is, while issuing notice on a complaint under Section 12 of the Domestic Protection of Women from Domestic Violence Act, whether the magistrate is taking cognizance of any offense.
My lord, my submission to your lordship is this: section 12 relates to any domestic violence by the in-laws of the victim. If there is a violence, there is an offense. My lord, the word itself shows that it is not there. My lord, domestic violence shows because there is some kind of either mental, physical, or kind of any kind of, my lord, violence towards the victim. On that basis, my lord, that there is a complaint case. Otherwise, the wife would not have gone away. Because there is a violence, there is definitely this. And here, the only finding is that it is civil, so I will not go for 223. This is only the finding given by the trial court. Was civil in nature.
Okay. What is your next submission?
Next submission, my lord, as regards my petitioners, my lord, I am giving all the documents. First of all, I take your lordship to the definition of domestic violence shared household. My lord, not shared household, domestic relationship.
What is the stage of the case? Is it stayed?
It's stayed.
Okay.
Domestic relationship, my lord, to the definition of Domestic Violence Act.
Which provision?
Provision 2D, 2F.
Yes.
Means a relationship between two persons who live or have at any point of time lived together in a shared household when they are related by consanguinity, marriage, or through a relationship in nature of marriage, adoption, or are family members living together as a joint family. In my case, my lord, the victim stays in Karimganj. Maximum of the petitioner stays in Dimapur, in Gauhati, and different places. Kohima, they have never been in, my lord, in a relationship stay at any point of time live together in a shared household. They have never, but I have given all the documents for her. As regards the husband, I am not there. As regards, my lord, my petitioners are there. I have given all the documents, my lord. Your lordship will start from the first, my lord. The petition number 1, Mariam Haq, agent number 48, wife of Animal Haq. My lord, here is the documents at page 19 onwards. My lord, this is at Kohima's document. At page 21, your lordship will find address, Aadhaar card, Kohima. Next, my lord, election commissions, annexure 322. This, my lord, Jahidul Haq, Rabia Sultana. Then, my lord, annex page 24. This is brother-in-law's appointment letter, my lord. Page 24, as regards the appointment letter, he stays in different place. Then page 29, annexure 6, my lord, the persons Sultana and Jahidul, they stays in Gauhati. Tenancy agreements. They never, my lord, they never shared any relationship with the wife. And from the complaint petition, my lord, your lordship may look into it, where it can, your lordship may look into it. Allegations is basically against respondent number 1, not others. Some vague allegations are there. And your lordship may look into the marriage took place on 14/1/24. And within a year, my lord, this domestic violence case has been filed. They, my lord, as regards, my lord, the definition clause, my lord, I was going through one of the judgments, my lord, where it says, if in para 20 of 22.2 HSC 301, while interpreting a definition clause, my lord, the court held, my lord, while defining the bank in that particular case, my lord, the Supreme Court held, my lord, the general rule of construction laid down by a enactment is subject to the context. To deviate from the defined meaning should record reasons to show the word expression in that particular provision carries a different meaning. Contrary context is not to be assumed or accepted easily in the absence of identification and reason to differ from the defined meaning. So, my lord, to differ from the defined meaning, the definition itself shows that, my lord, once upon a time, at past, present, they have stayed, sometimes at least for some days along with them. The victim stays in Karimganj, marriage took place in Karimganj, and my lord, that judgment, your lordship knows, it was reported in Criminal Appeal 2340 of 2023, August 8, 2023, my lord, as regard washing, my lord, where in a 482 and a 226 also, my lord, the court has held that, my lord, para 30, my lord, may I read slowly, I place it before lordship, where the judgment itself shows, my lord. With the lordship's permission, I'm reading, my lord. At this stage, we would like to observe something important.
What you want to emphasize?
The power in a 482 and a 226, where the court can look into the other relevant documents also, not only the complaint. You have to look into the overall circumstances over which the, my lord, the alleged thing has been done. And when the Supreme Court has held that your lordship is also, my lord, para 30, it has, your lordship, I will listen before lordship. At this stage, we would like to observe something important. Whenever an accused comes before the court invoking either inherent power under section 482 of the CRPC or extraordinary jurisdiction under article 226 of the Constitution to get the affair or the criminal proceeding quashed, essentially on the ground that such proceedings are manifestly frivolous or vexatious or instituted with ulterior motive for wreaking vengeance, then in such circumstances, the court owes a duty to look into the affair with care and little more closely. We say so because once the complainant decides to proceed against the accused with an ulterior motive for wreaking personal vengeance, etc., then he would ensure that the affair complaint is very well drafted with all necessary pleadings. The complainant would ensure that the averment made in the affair complaint are such that they disclose the necessary ingredients to constitute the alleged offense. Therefore, it will not be just enough to the court to look into the averment made in the affair complaint alone for the purpose of ascertaining whether the necessary ingredients to constitute the legal alleged offense are disclosed or not in frivolous or vexatious proceeding. The court owes a duty to look into many other attending circumstances emerging from the record of the case over and above the averments, and if need be, with due care and circumspection, try to read in between the lines. The court, while exercising the jurisdiction under 482 of the CRPC or Article 226 of the Constitution, need not restrict itself only to the stage of a case, but it empowered to take into account the overall circumstances leading to the initiation, registration of the case, as well as the materials collected in the course of investigation. Take, for instance, the case on hand, then it is said because
You mark that paragraph and give that judgment.
But I read, place it para 30.
Okay, anything else?
My submissions are twofold here. My lord, the 223 should have been taken care of by the learned trial court.
Okay.
And my lord, another submission, my lord, this petitioners, I am not saying for the husband, these petitioners have never in their past or in present have, as per the definition of 2F, my lord, at any point of time live together in a shared household. And that is what, my lord. Maybe in a day, in the marriage day, they may have come, but they have not lived together in a shared house. And that for that I have placed all my documents. That too are my submission.
Okay. Yes, Mr. Majumdar. Second case.
Emphasize on the legal provision, whatever has been submitted by me. I rely on that. The notice under section 223 is also mandatory in this case, your lordship. Now, your lordship may kindly see the complaint. That is annexure 1 in my petition. your
Page
lordship.
number.
Page number 13. We start from page number 13. Your lordship, I
Yes.
gone through absolutely no specific allegation against the husband. In para 1, page para 1 is the date of marriage, so and so, so and so, so and so. Then para 3, wrongly, page 14. That the matrimonial life of the agreed person and the respondent start happily as the resident of the respondent number 1 with other family members started cohabiting with the respondent number 1 and also started discharging their matrimonial duties and obligation toward the family member of the and the relative of the respondent number 1. But the happiness did not last long due to the hot temperament of mood and negativeness as well as quarrelsome attitude of the respondent number 1, that is the husband, toward the agreed persons. No specific date. Next page, I am reading only the relevant portion, your lord. Next, after few lines. After that, the respondent start word behavior with the agreed person and by showing her facial skin problems that the respondent start harassing the agreed person by abusing word and the respondent number 1 threatened that he will divorce agreed person. Then the agreed person inform her father and describe about the mental harassment by the respondents rather any treatment for her suffer. Now, she has alleged that she is having some facial problem. For that, I abused her and I threatened to divorce her. This is the only allegation. Next, the bottom part. Mary, I'll continue reading, your lordship. Then, after getting information, the father of the agreed person visited the matrimonial house and could see the misbehavior of the respondents with the daughter. Then, respondent number 1 forcefully demanded the father of the agreed person to take her back to his house. The agreed person requested the respondent number 1 to allow her to stay with the respondent at her matrimonial house, but the respondent number 1 to refuse her request to stay at her matrimonial house and further demanded her wellness and facial fairness after treatment by her father, and also respondent number threatened agreed person that he will divorce her if she insists to stay with him. That is the respondent number 1. That having no alternative, the father of the agreed person took her to his house and visited the doctor for treatment. This is the allegation. And then your lordship, in para 4, page 16, the agreed person is a simple-minded woman having intention to maintain her matrimonial house against her discharging her duty and obligations toward the household with dedication without any default to her obligation. In terms of return, the respondent number 1, along with other respondents, did not pay any respect toward her dedication and hard work for his family. After that, after few days, the agreed person expressed her willingness to have baby. Then the respondent number 1 refused her request desire by showing this or that, forcefully agreed her to take anti-pregnancy pill even the respondent forcefully aborted the fetus or at her womb, that the respondent restrain the aggrieved person from communication with any person, including her parents, your lordship. Now, these statements made in the previous para statements are quite contradictory, your lordship. These are the only allegations made against the husbands. What I have gone through now, your lordship, may kindly see, your lordship. Then I will also like to, in para 6, page 18 of the complaint, that the father of the aggrieved person several times tried to contact his daughter, but he found the mobile phone of his daughter was switched off. Then he contacted the respondent number 1 and asked about his daughter. Then the respondent number 1 replied that he is out of station, and after reaching home, he will contact him with the aggrieved person. But after waiting, no response reached out from the side of the respondents. Then the father of the aggrieved person, along with his wife, visited the house of the respondents. But the respondent number 1 to 6 did not allow the father and mother of the aggrieved person to meet with her. Then the father of the aggrieved person approached one Aidu Roman Chaudhary, working president of Naga Muslim and Council, and expressed about the incident. Then the president of Naga Muslim Council, along with other members, on 15/7/25 recovered the aggrieved person from the illegal confinement of the respondent number 1 to 6. Now, this is the statement which is absolutely concocted and false. It reveals from the affidavit, your lordship, page 31. Page 31. This is by the Naga Council President Aidur Rahman Chaudhary, your lordship. The bottom paragraph, the above statements are completely false and fabricated, because the father of this Sanas Chaudhary, that is a victim, never approached me as stated above. As per my knowledge on so and so, the father mother of Sanas Chaudhary, along with one person, came to Dimapur and spent their night along with their daughter at the residence of Sadiqul Haq, that is the husband.
From where this affidavit has come?
Lordship,
From where this affidavit has come?
this has been shown by the Aidur Rahman Chaudhary when they made an allegation. I make an inquiry and then he showed no, nothing. This is absolutely false. Then, your lordship, I will like to take the medical report of the girl, your lordship, Annexus 6, page 35. Your lordship, kindly see. 35. Now, what happened, your lordship? My wife, your lordship, she voluntarily left on 2/7/25 for a matrimonial house. And after regular search, thereafter, I myself, your lordship, approached the woman police station, Dimapur, which I have stated in my para 5, your lordship, specific statement. Thereafter, the petitioner informed the concerned woman police station, Dimapur, para 5, page 6, your lordship, page 6, Dimapur. Accordingly, on 2/7/25, a GD entry has been made by the woman police station, Dimapur, Nagaland, and thereafter sent the complainant to the district hospital, Dimapur, for medical checkup. After medical checkup, the doctor found that the complainant is suffering from adjustment disorder and psychiatric, and accordingly advised the complainant and her husband to consult with psychologist for proper treatment. Now, your lordship may kindly see Annexer 5, page 38. This is by the officer in charge, Women Police Station. I have the honor to request you to kindly examine the below person and furnish with a report of the reverse of this nature and the bodily injured on him, her. Particular of the person, Shahnaz Chaudhary. This is the wife. Now, next page. Next page, your lordship. The medical officer report. I have the honor to request you to kindly examine the below person so and so, so and so. Bottom portion is the comment of the doctor. Your lordship,
Where are you reading?
page 34. Not 34.
34?
34.
Yes.
Page 34. And it is a continuation of Annex of 5. Your lordship. Bottom portion, advice for psychiatric consultation. Lordship got last line. Advice for psychiatric consultation.
Yes, what you want to say?
Yes. Then next, Annex of 6. The girl adjust.
Where is Annexure 6? Don't.
Page 35.
Yes.
Page 35. This is the impatient adjustment disorder, bracket, tocophobia. What is tocophobia, your lordship? Tocophobia is an extreme pathological fear of pregnancy and childbirth. It is the fear of pregnancy and childbirth. Now, the wife has made an allegation against the husband that she intended to have a child and I have forced her to abort the child. The wife herself suffers from tocophobia, which is the fear of pregnancy and childbirth. So this is the only basic allegation against the husband, your lordship. Other than that, I have abused or person cruelty. That apart, your lordship, legal submission here, my learned senior friend already submitted. And in spite of all this, I am ready to take her back and I am ready to undergo her treatment, your lordship. It is only at the advice of her parents that this instant complaint has been lodged, your lordship. And moreover, there is no report.
What relief she is seeking before the magistrate?
She is seeking relief under section. She is seeking page 22 of the complaint. Start from page 21. Bottom portion. In the premises, the 80% pay for
Residence order, maintenance order,
by passing
protection order.
create any obstruction, the disturbance as and when the agree person want to enter into. Nobody is preventing her. Number B, for passing an order prohibiting the respondent from committing any act of domestic violence or any threat threatening to the agreed persons. Number C, for passing an order in favor of the complainant and against the husband for the right to reside in a shared household, a separate, which is also not correct, your lordship, as my learned friend has also already stated. A separate accommodation of same standard provided by the respondent under the premise provision of section 17. D, for passing an order for protection and residence under section 18 and 19. E, for passing an order in favor of the complainant aggrieved person and against the respondent, granting monetary relief under section 20. These are the main prayer, and F is the. So let there be a mediation, your lordship. I am ready to take her. I am ready to undertake her treatment also. Basic allegation against the husband is that she wants to have a baby and I pressurize her not to have the baby. In fact, she herself is suffering from tocophobia, which is the psychological.
Have you appeared before the court? You appear and you tell that you are ready to take her back.
No. after the impugn order taking cognizance of the complaint and not on the offense, taking cognizance of the complaint under section 12. Your lordship have ample power under section 528. It exercises inherent power to take appropriate, to pass an appropriate order or direction, your lordship. So let there be an high court mediation, your lordship.
Yes. Yes, Chaudhary. Yes.
Your lordship may look into the order where the notice was issued to the our petitioners and were asked to submit our assets and liabilities. Your lordship may just turn to section 12, subsection 4 of the act.
Yes.
That by this was not followed. The magistrate shall fix the first date of hearing, which shall not ordinarily be beyond 3 days from the receipt of the application by the court. But whether that was done or not. Now, here from the record, it shows there was no hearing, nothing was done. Just the application was filed and my lord, notice was issued that you submit your assets and liabilities. And the word here, the word is shall fix the date of hearing.
Now notice is to be served.
After hearing, my lord, then only the notice will be.
No. Notice for hearing.
Notice for. But
Section
here,
13.
my lord, here, they have said here, my lord, that you submit your assets and liability. There is no notice for hearing. The order itself shows that, my lord, you just submit your assets and liability. The order is at page 55. Issue notice the respondent filing written statement and disclosure of assets and liability.
Yes.
The petitioner 1381/2025, Lordship. The petitioner one is Mariam Haq, who is aunt of husband. Lordship.
Oh, which one?
Mariam Haq,
1381.
yes, 1381.
Huh.
Mariam Haq is aunt of husband.
Okay.
Rabia Khatun is daughter of Aunt Samsun Nehar. Petitioner number 3. Rabia Sultana is the daughter of petitioner number 3.
Okay.
And petitioner number 3 is sister of father-in-law.
They are all relative of your husband.
And Jabedul Haq is brother-in-law. And Monira Haq, Lordship, mother-in-law. So these are the first 5 petitioners before your Lordship challenging the order, Lordship. So my question is that, Lordship, if they are challenging the order, then they ought to have filed an appeal as per there is a provision of section 29 in the DB Act itself. Any order they are challenging, they are required to file an appeal, Lordship. There shall lie an appeal to the Court of Session within 30 days from the date on which the order made by the magistrate is served on the aggrieved person or the respondent, as the case may be, whichever is later. So the order they cannot challenge by way of quashing, Lordship. If they want to challenge the want to proceed with quashing that there are some vague allegations against the petitioners, I have taken information, Lordship, the petitioner number 2 and 3, though they are resident of Karimganj, but as their father, husband before his death stayed at Dimapur in a rented house. So after his death, they lived there with their aunt lordship, the husband's family lordship.
No, is there any statement to that effect in your complaint?
Petitioners were living together in the joint family, so they were made as respondents, and there is a common allegation that at the instigation of the respondent number 226, she was tortured, and there was, lordship, no physical torture, only mental torture in favor of the victim, to such a extent that, lordship, she developed psychological disorder, and she was given some medicines by the husband himself. He taken her to the doctor, and there were some medicines prescribed. Lordship, kindly see the annexure my learned friend has already shown before your lordship the medical documents of that.
No, no, before going to that,
We will come later on to that.
before going to that, you make your submissions on the point
Complaint petition.
that the respondent number 2 to 6 were not in a domestic relationship within the meaning of section 2F, as they were not living together.
Page 40, paragraph 3, wrongly written as paragraph 3, ought to be paragraph 2. That the matrimonial life of the agreed person and the respondent started happily at the residence of the respondent number 1 with other family members. That they all were living there and started cohabitation with the respondent number 1, and also started discharging her matrimonial duties and obligations towards the family members of the family members and the relatives of the respondent number 1. But the happiness did not last long due to the hot temperament of mood and negativities of, as well as quarrelsome attitude of the respondent number 1 towards the agreed person, and could discover the real nature of the respondents within a short period. That after few days of marriage, the agreed person suffered from facial skin allergies, which later clinically detected due to the material substances used in facial beauty cream during marriage functions. After that, the respondent started weird behavior with the agreed person, and by showing her facial skin problem, that the respondent started harassing the agreed person by abusive words, and the respondent number 1 threatened that he will divorce agreed person. Then the agreed person informed her father and described about the mental harassment by the respondents, rather any treatment for her suffering. She was not given any treatment, and rather she was informed by the husband that you call your father and let him took you to your parents' house. After getting information, the father of the agreed person visited her matrimonial house and could see the misbehavior of the respondents with his daughter. Then respondent number 1 forcefully demanded the father of the agreed person to take her back to his house. The agreed person requested the respondent number 1 to allow her to stay with the respondent number 1 at her matrimonial house, but the respondent number 1 to 6 refused her request to stay at her matrimonial house, and further demanded her wellness and facial fairness after treatment by her agreed person father. And also respondent number 1 threatened agreed person that he will divorce her if she insists to stay with him. That having no alternative, the father of the agreed person took her to his house and visited the doctor for treatment. Later on, the agreed person got relief from suffering and returned back to her matrimonial house with a hope to restart a happy conjugal life with the respondent number 1 along with the other respondents, but all in vain, as the behavior of the respondents became worsened after her appearance. So there is an allegation that all the family members were residing together. The brother-in-law, he works at Gauhati, but very frequently he visits house. And there are some allegation in paragraph 4 against respondent number 2 to 6. The 7th line, your lordship will find respondent number 2 to 6 said that the status of the agreed person's family is very low in compared to that of his family. An agreed person has not come to his house as his wife, but as a maid. The respondent numbers 3 to 6 have been frequently abusing and giving threats to the agreed person and her family members by showing their status. The respondent number 1 always shows very aggressive nature and angry gesture and even beats the agreed person by the influence and provocation of the respondent number 2 to 6. In several occasions, the respondent number 1 husband assaulted physically the agreed person without any person. So against husband lordship, there is an allegation of assault also, physical lordship, physical allegation, and here in this case provocation, and at the instance of the petitioners, the husband lordship harassed her. So there are allegations in this case. It is not a case that there are no allegation against the petitioners. So if they are willing to contest the case lordship, so they can appear before the learned trial court and they can disprove these facts by contesting the trial lordship. In this case lordship, there are some allegations, so that has to be proved during trial. And there are some medical documents which they have annexed along with the petition in 334 lordship. That will show that there are some psychological problem.
What is your submission
If
regarding that 223 was not followed?
For that, they have to file an appeal challenging the law.
No, and that is one counter. Assuming that, leaving apart that, what is your submission? 223, whether court was wrong?
Sir, lordship was judicial. They are not criminal, not civil. So lordship issuing notice to filing written statement. And this is as per Rajneesh versus Nehar, along with written statement, assets and liabilities to be filed, lordship. So there is no fault on the part of the trial court that while issuing notice, they are directed to file assets and liabilities. This is the first notice, and first notice was always served to file the service, lordship, the written statement. As per Rajneesh and Neha lordship, it is mandatory to file assets and liabilities along with the written statement.
DV cases also.
Yes, lordship, in DV cases also. And there are some allegations that she is suffering from tocophobia, lordship. That is a condition which is extreme pathological fear of pregnancy and childbirth. But our allegation is that he has done some medication to kill the fetus, lordship. So these are the disputed facts. These are to be proved before the trial court. They are saying she is having tocophobia and she is saying she wants baby, lordship. So disputed facts came. These are required to be proved by adducing evidence before the trial court. And there are allegations. 482 will come if the allegations are vague and lordship not on the basis of records, then only the 482 will come. And here, lordship, the allegations are direct to the husband as well as to the family members also. And lordship, the affidavit, kindly see that affidavit my learned friend has shown before your lordship. Annexure 4, page 31.
In next case.
334. That he filed an affidavit swearing that there was no such incident. This is the submission made by.
Yes.
Affidavit is I, Ahidur Rahman Chaudhary, son of late M. Rahman Chaudhary. But signature is G. Rahman, lordship. Affidavit was sworn by G. Rahman, deponent G. Rahman.
So your submission is that
Not an affidavit by Ahidur Rahman Chaudhary. Who is G. Rahman? They have not disclosed in their petition, lordship. Their case is that Ahidur Rahman Chaudhary mediated, so he filed an affidavit that in para 2, he stated that in the paragraph 6 of the Miss Domestic case number so filed by Shahnaz Chaudhary before the Honorable Chief Judicial Magistrate Sri Bhumi, wherein in the paragraph 6 of the petition she stated the father of the agreed person along with his wife visited the house of the respondent, but the respondent number 1 to 6 did not allow father and mother of the agreed person to meet with her. Then the father of the agreed person approached Ahidur Rahman Chaudhary, working president of Muslim Council, and expressed about the incident, then the President of Muslim Council along with other members on 15/7/25 recovered the aggrieved person from the illegal confinement of the respondent number 126. The above statements are completely false and fabricated because the father of Shehnaz Chaudhary never approached me as stated above. As per my knowledge, on 14/7/25, the father, mother of Shehnaz Chaudhary along with one more person came to Dimapur and spent their night along with their daughter Shehnaz Chaudhary at the residence of Sadiqul Haq before taking back their daughter back to Karimganj on 15/7/2025. That prior to 15/7/2025, on several occasions,
Your submission is that this affidavit has
state the petition also that they have stated that Ahedur Rahman signed an affidavit.
okay. Anything else?
Lordship, in Madan Lal, in Prabhat Tyagi, Lordship, paragraph 75. Page 138. In view of the above discussion, the three questions raised in this appeal are answered as under: whether the consideration of domestic incidents report is mandatory before initiating the proceedings under the domestic violence.
Para.
75, Lordship.
Yes.
Last page.
Yes.
75.1. Whether the consideration of domestic incidents report is mandatory before initiating the proceedings under the Domestic Violence Act.
No, that is not their plea. They have not taken that plea that DAIR should have been considered before issuing notice. Their plea is that 223 should be followed, and then 2 to 6 are not in a shared household. Number 2.
Domestic Violence Act, this domestic incident report is mandatory. But where the Honorable Supreme Court is saying that domestic incident report is not mandatory,
Time of issuing notice.
then the question of 223 will not come. This is the provision itself in the special statute. Whether the consideration of domestic incident report is mandatory before initiating the proceedings under DV Act 2005 in order to invoke substantive provisions of section 18 to 20 and 22 of the said Act. It is held that section 12 does not make it mandatory for a magistrate to consider a domestic incident report filed by a protection officer or service provider before passing any order under the DV Act. It is clarified that even in the absence of a domestic incident report, a magistrate is empowered to pass both ex parte or interim as well as final order under the provisions of the DV Act. 75.2. Whether it is mandatory for the aggrieved person to decide with those persons against whom the allegations have been levied at the point of commission of violence. It is held that it is not mandatory for the aggrieved person when she is related by consanguinity marriage or through a relationship in the nature of marriage, adoption, or are family members living together as a joint family to actually reside with those persons against whom the allegations have been leveled at the time of commission of domestic violence. If a woman has the right to reside in the shared household under section 17 of the DV Act, and such a woman becomes an aggrieved person or victim of domestic violence, she can seek reliefs under the provisions of the DB Act, including enforcement of her right to live in a shared household. Whether there should be a subsisting domestic relationship between the aggrieved person and the person against whom the relief is claimed, it is held that there should be a subsisting domestic relationship between the aggrieved person and the person against whom the relief is claimed vis-a-vis allegation of domestic violence. However, it is not necessary that at the time of filing of an application by an aggrieved person, the domestic relationship should be subsisting. In other words, even if an aggrieved person is not in a domestic relationship with the respondent in a shared household at the time of filing of an application under section 12 of the DB Act, but has at any point of time lived so or had the right to live and has been subjected to domestic violence or is later subjected to domestic violence on account of the domestic relationship, she is entitled to file an application under section 12 of the DPA. So, Lordship, it is not mandatory that while she filed the application, the relatives were there or not. But relatives were there after marriage and they tortured her to that extent, Lordship, she developed psychological problem. And later on, the doctor was again shown by the father and as well as by the husband. At that time, her condition was stable. In 334, page 39, annexure 7, fit and stable at the time of examination. That is on 15/7/25, while she was taken back by her father from her matrimonial house. So there are questions which are raised by them that those who are not Lordship devolved at the time of her living at the residence of the husband. But Lordship, if they want to prove those facts, Lordship, they can very well appear before the learned trial court and state their case by filing a written statement. So they will be exonerated from the complaint, Lordship. Then husband, there are some allegations, specific allegations. So these are disputed facts, Lordship. These cannot be, it is not, Lordship, principle of law that Domestic Violence and Lordship Act proceedings can be quashed if the allegations are vague, Lordship. There are serious allegations. Her fetus was removed by the husband. She was,
When it can be quashed?
if the DBA Act allegations are vague, Lordship.
Vague means
Like there is
it
no
does not make out a case
Yes.
of domestic violence.
Yes.
Okay. Anything else? Heard any reply?
Reply as regards this judgment, Mala.
Which judgment?
Judgment my sister has placed.
Prabhati Agi.
Prabhati, here, Mala, our submission is this domestic violence, the definition of 2A. We have never been in staying there for any time with them.
But she has stated that you stayed with them.
Well, that is why my judgment of 482. Your Lordship will find from my documents that I have submitted. My Lord, when there is a frivolous case, they will be well drafted. That has been submission in the 480, the Supreme Court judgment. By only seeing that complaint
No.
petition and the FIR, my Lord, your Lordship will look into
No.
all the documents.
You are disputing the facts averred by the.
My Lord, because it has been said that in a 482 application, the Honorable Court has to go beyond it and to see it.
Okay, suppose I go beyond that.
My Lord, your Lordship will look into the documents.
Documents, I look into the documents.
And your Lordship,
How I will
your Lordship will find
give
that
finding on facts?
finding the fact that I am staying in Kohima, they are staying in Karimganj. I have never, because
No, you have, assuming for argument's sake, you have produced some documents of Kohima.
Aadhaar card I have placed.
Aadhaar card. But that does not say, made out a case that at all point of time you stay in
My Lord, the
that.
definition says that, my Lord, visiting one time will not do. My
But-
Lord, 2F says, that if I read 2F carefully, my Lord,
Yes.
2F says, means a relationship between two persons who live or have at any point of time live
Living.
together in a shared house.
Yes.
Live together. My Lord, visiting somebody's house, I visit my sister's house, that doesn't mean I have lived together with the sister. Live together, my Lord, for a considerable period of time we have been living together.
Yes.
Visiting once or twice doesn't mean, my Lord, that we have lived there in the shared household.
Okay.
And my Lord, that does not give say that, and that is also true. At the time of filing our application under section 12, it need not require that I have to stay there. That I admit, my Lord, as per this Prohibitions Agi's judgment 75.3.
And regarding mediation, Lordship, I have already talked with my learned friend earlier also, before Honorable High Court, Lordship. They said that they do not want to take her back. So mediation by giving some lump sum amount, Lordship. That was informed to the father of the victim. The father said that she wants to coexist with her husband. She's still ready to go to matrimonial house. So even, Lordship, they are ready to take her back at this stage. They can very well say that before the learned trial.
No, let there be a petition before this honorable court, your Lordship. Otherwise, it is
After
not.
arguing this case.
No,
lordship,
it
to
is not,
that extent.
to my humble submission, your lordship, it might not be a independent decision of the husband, wife, your lordship. Yes, there will be mediation between the wife and the husband or other members should not be there, and there will be a mediation between the wife and husband, your lordship.
No, we'll not close the
Yes.
option of mediation,
Yes,
but
we should-
keeping pending this case has to be disposed of. Where do you stay now? Karimganj or Nagaland?
Husband,
Dimapur,
And wife,
Karimganj.
where the mediation will take place?
Yeah,
Criminal petition number 334/2026. Also Miss R. Chaudhary, Learned Senior Counsel, assisted by Miss S.E. Murtaja, Learned Counsel for the respondent number. Respondent number.
State is there.
Why state is by respondent number 2. Also Mr. P.S. Locker, Learned Counsel for respondent number, Learned Additional Public Prosecutor representing the state of Assam. By this common judgment, this court proposes to dispose of 2 criminal petitions, namely criminal petitions number 1381/2025 and criminal petition number 334/2026 as in both the criminal petition, same relief has been prayed for, namely for quashing of the proceedings of Miss DV case number 37/2025 pending before the court of Learned Judicial Magistrate First Class number 2 Sri Bhumi. In both the criminal petitions, the order dated 6/9/2025 passed in Miss DV case number 37/2025, whereby notices were issued to the present petitioner in the aforesaid case has also been impugned. The facts relevant for consideration of the above noted criminal petitions, in brief, are that the respondent number 2 herein, namely Miss Shahnaz Chaudhary, has filed a complaint under Section 12 of the Protection of Women from Domestic Violence Act 2005 before the Court of Learned Chief Judicial Magistrate Sri Bhumi. The said case was transferred for disposal. Now, said case was assigned for disposal to the Court of Learned Judicial Magistrate First Class number 2 Sri Bhumi. In the complaint petition filed by the present respondent number 2 before the trial court. She has contended that she was married to the petitioner of the criminal petition number criminal petition number 334/2026, on 14/1/2024, as per Islamic rituals and law at Batar Ashi, Karimganj, Shribhumi. And after her marriage, the respondent number 2 started living along with her husband and other family members at her matrimonial home. However, it is alleged in the complaint petition that after some time, owing to bad temperament of the husband of the respondent number 2 and his quarrelsome attitude, matrimonial discord arose between them, and she was mentally tortured by the petitioners of both the above mentioned criminal petitions. Several allegations have been made in the complaint petition by the respondent number 2. Stop. On receipt of the complaint filed by the respondent number 2, the trial court, by its order dated 6/9/2025, issued notice to the opposite parties / above named petitioners and fix next date of the case on 8/10/2025 for service report / filing of written statement / DIR stands for domestic incident report, and for submission of and for disclosure of assets and liabilities of the respondents. Being aggrieved with the aforesaid order, the present petitioners, the above named petitioners, have approached this court. Next para. Mr. P.K. Roy Chaudhary, learned senior counsel for the petitioners in criminal petition number 1381, that is the opposite party number 2 to 6 in Ms. J case number 37/2025 within bracket DV, has submitted that the trial court had erred in issuing notice to the present petitioners without complying with the procedure as laid down in section 223 of BNSS before issuance of note. 223 of BNSS 2023. Stop. He submits that since the complaint under Section 12 of the Protection of Women from Domestic Violence Act 2005 also arises out of domestic violence, and since the the aforesaid act does not prescribe any procedure for procedure to be followed in case under the aforesaid act, comma, the procedure laid down in BNSS is to be followed. He therefore submits that the trial court erred in issuing notice to the present petitioners and in taking cognizance of the complaint filed by the respondent number 2 without complying with the mandate of section 223 of BNSS, and as such he submits that said order is liable to be quashed. Stop. The learned senior counsel for the petitioners, criminal petition number 1381/2025, also submits that the trial court also erred in issuing notice to respondent number in opposite party number 2 to 6 in the above mentioned complaint case without ascertaining the fact that the petitioners in criminal petition number 1381/2025 were not in a domestic relationship with the respondent number 2 within the meaning of the phrase domestic relationship as defined in section 2 within bracket small f of the Protection of Women from Domestic Violence Act, 2005. He submits that one of the essential ingredient for a relationship to be regarded as a domestic relationship is that the family members who are claimed to be in domestic relationship with the aggrieved person must have resided together or must be living together as a joint family in a shared household. He submits that the petitioners in criminal petition number 1381 are
Sorry, in a complaint petition only, our address is given in Dimapur. Complaint petition itself shows our address is given in Dimapur. Page 39, Your Lordship.
but she's also staying in Dimapur.
Her address is given in Karimganj.
No, but after marriage, she stayed.
Well, because she says she was staying with the husband in Karimganj.
Where she says.
Well, Your Lordship will find, my lord, Your Lordship, the marriage, paragraph 1. Page 40.
Para 1 is where marriage took place.
Then thereafter, my lord, if you read it whole, my lord, they with the respondent number 1, they were staying in Karimganj.
No, is it your submission that she never stayed in Dimapur?
My lord, what my submissions, my instructions goes here, my lord, they say this relative stays in Dimapur and she was staying in Karimganj. That was my instruction. As a shared household, they were not living in together in the same shared household.
In Dimapur, she.
My lord.
Okay. One Kili last line.
And one submission 12.4 is also there, man. 12.4. One submission.
If any members who will stipulations, the taking person must be residing together or must be living together in the joint family sheltered also.
A shared house. One 381 of 2025 are the you are resident of all.
Well, the address is given.
Number 2 is of Rabia Sultana is of Karimganj.
Now, my lord, I am staying in Karimganj.
3 is in Karimganj.
My lord. But we are staying separately, not with the same.
Okay. Never stayed. Never stayed. Last time. Last word. Never stayed. Never stayed together with respondent number 2 in a shared household. They only occasionally visited. You visited the household.
Only, but maybe in once or twice in a year. But it's not that every month or every week.
Visited the respondent number 2's residence, matrimonial residence, and same cannot be regarded as living together as in a joint family as required by the provision contained in section 2 within bracket F of the Domestic Violence Act of the Protection of Women from Domestic Violence Act 2025. He also submits that as per the trial court also erred in issuing notice to the petitioners without affording the opportunity of hearing to them as required under section 12 within bracket 4 of the Protection of Women from Domestic Violence Act. What is your submission? That
12.4 is related to domestic. 12.4 relates to section 30. Here, my lord, domestic inquiry report is called upon. For that, my lord, if I read 12.4 is with to 13. 13 says the my lord, your lordship will look into 13. Service of notice. A notice of date of hearing fixed under section 12 shall be given by the magistrate to the protection officer, who shall get it served by such means as may be prescribed on the respondent or any other person as directed by the magistrate. 12.4 has to be read with section 13. My lord, here it was in the order itself shows the report was called from the DI. Domestic incident report was. So where is that compliance of 12.4 read with section 13? Service of notice.
what it requires.
My lord, because at least a notice of date of hearing fixed under section 12 shall be given magistrate to the protection officer, who shall get it served by such means as may be prescribed on the respondent on any other person as directed by the magistrate with a maximum period of 2 days and further reasonable time as may allowed by the magistrate on the date of receipt. A declaration of such protection officer is such form may be proof.
Stop. He also submits that there has been also a violation of requirement of section 13
12(4)
of the Protection of Women from Domestic Violence Act 2006 when read along with section 12 within bracket 4 of the said act. Stop. Learned senior counsel for the petitioner also submits that petitioners in case number 2 demo or in criminal petition number 1381/2025 also submits that the allegations made in the complaint petition are mainly directed against the husband of the respondent number 2. And as such, same does not make out a case against the petitioners of criminal petition number 1381/2025 to justify issuance of notice to them under section 12 of the Protection of Women from Domestic Violence Act 2005. He also submits that what documents you have furnished?
From annexure 1, my lord, Aadhaar cards, then my lord, PAN card, we have given my lord, election commission's report.
He
Fine.
also submits that to substantiate their claim that the petitioners were not staying with the respondent number 2 in a shared household. They have annexed some certain documents pertaining to the petitioners like Aadhaar card,
Election card.
Aadhaar card and
Electoral photo ID card, appointment order,
electoral photo ID card,
appointment order,
appointment orders,
tenancy agreement,
to show that they were living separately from the respondent number 2 when the act of alleged domestic violence respondent number 2 stop continue. He submits that this court, while considering an application under section 528 of BNSS for quashing a criminal proceeding, can take into consideration other attending circumstances emerging from record of the case. Stop. As such, he submits that taking into consideration the above facts, the complaint under section 12 of the Protection of Women from Domestic Violence Act 2005 filed against the petitioners of criminal petition number 1381/2025 may be quashed. In support of his submission, learned senior counsel for the above named petitioners has cited following rulings. You have cited one ruling only. Following ruling: Muhammad Wajid and another versus State of UP and others, reported in 2023, INSC 683. Stop. On the other hand, learned Mr. R. Majumdar, learned counsel for the petitioner in criminal petition number 334/2026, has submitted that he adopts the submission of learned senior counsel for the other petitioner as regards the objection regarding taking cognizance of the complaint filed by respondent number 2 by the trial court without following the procedure as laid down in section 223 of the BNSS 2023. He submits that the respondent number 2 has lodged the complaint under the Protection of Women from Domestic Violence Act 2005 against the present petitioner, who is the husband of respondent number 2, making vague allegations against him. Without specifying, without mentioning any specific date or time of alleged incident of domestic violence on the respondent number 2. He submits that. Where is that statement that she went out of? You filed the
Para. Page 6, para 5. Seeing the date of when the complaint
he submits that after the marriage of the petitioner with the respondent number 2, the present petitioner and the petitioner in criminal petition number 334/2026, within bracket, the husband observed certain abnormal behavior on the part of the respondent number 2, and on 2/7/2025, the respondent number 2 left the matrimonial left her matrimonial home without informing anyone. And in this regard, the husband also informed the matter to the Women Police Station, Dimapur, Nagaland, and on the basis of the said information, a GD entry bearing GD entry on 2/7/2025 was also made in the said police station. Thereafter, after vigorous search, the respondent number 2, thereafter he submits that thereafter, after vigorous search, the respondent number 2 was recovered and was referred to for medical checkup in district hospital Dimapur. He submits that the medical examination of the respondent number 2 indicates that she was suffering from some psychological problem and was referred for psychiatric consultation. He also submits that the medical examination report of the respondent number 2 also reveals that she was also suffering from adjustment disorder and tocophobia, within bracket, fear of pregnancy and childbirth, bracket close. He also submits that the petitioner in criminal petition number 334/2026 is ready to you are ready to take back or what? Ready to settle the dispute amicably with the respondent number 2, and therefore he prays for referring this matter to mediation. He otherwise submits that on the grounds stated in the criminal petition, the proceedings of Miss DV case number 37/2025 are liable to be quashed. Stop. On the other hand, Miss R. Chaudhary, learned senior counsel, appearing for respondent number 2, submits that both the criminal petitions filed by the opposite parties of the Miss DV case number 37/2025 are not maintainable in its present form. She submits that in both the criminal petitions, the petitioners are aggrieved with the order of issuance of notice to them, order dated 6/9/2025, passed by the Judicial Magistrate First Class number 2 Sri Bhumi in Miss DV case number 37/2025, whereby notices were issued to the petitioners. She submits that if the petitioners are aggrieved with the aforesaid order, the proper course which was open for them was to prefer an appeal under section 29 of the Protection of Women from Domestic Violence Act, as the aforesaid order is an appealable order. She further submits that there is a limitation period prescribed for preferring that appeal, that is of 30 days, and only to avoid the limitation prescribed, the petitioners cannot approach this court by filing an application under section 528 of BNSS. Stop. She further submits that the trial court did not commit any mistake by issuing notice after receipt of after filing of complaint by the respondent number 2 under section 12 of the Protection of Women from Domestic Violence Act 2005. She also submits that the proceedings under section 12 of the Protection of Women from Domestic Violence Act 2025 is a quasi-civil. Is it your submission? Quasi-civil proceeding, and it is not, and no offense is alleged to have been committed. Again, in the said application, the relief prayed for by the applicant, by the respondent number 2, where the relief in the nature, in quasi-civil nature, like maintenance order, protection order, and shared household order. He submits that no cognizance of offense is taken in a proceeding under section 12 of the Protection of Women from Domestic Violence Act 2005. Hence, question of following the procedure prescribed under section 223 of the BNSS, which she submits that is required only when the court takes cognizance of an offense on a complaint, which
Of the Therefore, in light of all above, I deem it fit to take cognizance of the complaint under section 12 of Protection of Women from Domestic Violence Act.
no, but no offense.
No, only for 12.
12 is not an offense. What is your submission?
Offense taken.
For cognizance of of the complaint. के लिख ले? Is required. She submits that in the instant case, the trial court has not taken cognizance of any offense, but has taken cognizance of the complaint under section 12 only. She also submits that, next para, learned senior counsel for the respondent number 2 has also submitted that the invoking of powers under section 528 by this court would have been justified had the complaint petition filed by the respondent number 2 did not disclose any incident of domestic violence. However, in the instant case, the allegations against the petitioners of both the criminal petitions have been made by the respondent number 2 in her complaint. Hence, she submits that this is not a fit case to invoke the powers of this court under section 528 of BNSS to quash the proceeding of the Miss Domestic Violence case number 37, Miss DV case number 37/2025. She also submits that in her complaint petition, the respondent number 2 has categorically averred that after the marriage with the petitioner of criminal petition number 334/2026, she happily resided in the residence of criminal petition number in the residence of her husband at Dimapur, with other respondents. Hence, she submits that the petitioner was in a domestic relationship with hence she submits that the respondent number 2 was in a domestic relationship within the meaning of the phrase as provided in section 2 within bracket F of the Protection of Domestic Violence Act 2005. She also submits that the disputed questions of fact cannot be gone into in a proceeding under section 528 of the BNSS by this court, and it is for the trial court to decide the same. She also submits that there is no requirement of law that at the time of filing the application under section 12 of the Protection of Women from Domestic Violence Act 2005, the agreed person must be living with the respondents. What is required is that she had lived at any point of time with them and was subjected to the incident of domestic violence, which she submits that is categorically averred in the averments made in the complaint filed by the respondent number 2. Bhajanlal, why you have referred to Bhajanlal?
Categories. Record where the washing can be.
She also submits that the petitioners have failed to made out a case for invoking the jurisdiction of this court under section 528 of BNSS in light of the guidelines laid down by the apex court in various judgments, including the judgment of
State.
State of Haryana versus Bhajanlal reported in
SCC.
1992 Supply 1 SCC 335. She has also cited another ruling of the apex court in the case of Prabhati Agi versus Kamlesh Devi reported in 2022 8 SCC 90, page 90. Next paragraph. Learned Senior Counsel for Respondent number 2 has also submitted that on an earlier occasion when an offer of mediation was made by the other side, it was communicated to the respondent side that the husband of the respondent number 2 is not eager to take her back. Hence, there may not be any prospect of mediation. However, she submits that the efforts of mediation can still be made before the trial court, where the complaint of the petitioner is pending. Stop. She therefore, submits that that both the criminal petition filed by the petitioners are liable to be dismissed. Stop. I have considered the submissions made by the learned counsel for both sides and have gone through the materials available on record. I have also gone through the rulings cited by both sides in support of their respective submissions. Stop. Don't. I'll go through the judgments and I'm reserving the judgment.
Oh, what I may like to add, Your Lordship. Mediation not be at is Karimganj because I will be pressurized, Your Lordship. There should be an independent mediation between the wife and husband. So at neutral place, Gauhati, Your Lordship. This is my humble prayer. Because otherwise she will be influenced by her parents.
Lordship has recorded the submission of my learned friend that on 2/7/25 I left the matrimonial house, Lordship. There your Lordship has recorded that GT entry was made first, then she was recovered. But it
She was recovered first.
Yes.
Yes. That correction I have noticed. That correction I will make.
She is recovered first, then she was taken to police and GT entry was made and then medical was done. After recovering, why GT entry was necessary.
Okay, I'll take into consideration.
Obliged.
I'm taking a short break.
And right now, the lower court, my lord, the court below gave Zimma to the respondent number 2.
Vehicle is in.
Already in Zimma, my lord, they have given Zimma to respondent number 2. But these owners, they receive money from me from 45 lakhs. Only needs to hear lordship to confirm whether they received the copy or not through the OC file. that they can do, my lord, that, yes.
You can also take steps by speed post,
Already I have taken mine.
whether it is served or not.
That is returned also.
If without service.
Because they are not available, they are showing that, my lord, because we have given the copy on the address, my lord, given in the FIR, my lord. Mobile number also given in the FIR, my lord.
Okay, you may inquire whether it is served or not. Heard Ms. S.K. Narges, learned counsel for the petitioner. Also heard Mr. P.S. Locker, learned additional public prosecutor. Office note dated 29/5/2026 shows that the notice to be issued to respondent number 2 and 3 through the Office of Learned Public Prosecutor was submitted by the petitioner on 29/5/2026. It said, however, no service report in respect of service of notice on the said respondent has been received. Under such circumstances, the learned additional public prosecutor is requested to take information regarding service of the notice on respondent number 2 and 3 from the officer in charge of jurisdictional police station and let this court know about the fate of the same on the next date fix.
Fine.
Yes, when?
Okay. Right.
Let this matter be listed on 5th.
Right.
Item 5 and 6.
May. The cases 5 and 6 are same, two different petitioners. The application is for on rejection of my Chigma application. Last 4 occasions they were there, a short time. There was an FIR lodge that is at page, my lord, 20. My vehicle, my mobile phone, everything has been seized. Even my bank account was seized and freezed on the same day. FIR is at page 20. My name is Promotional.
Yes.
Here the nature of work I am doing, discovery of fraud, and ultimately.
What was the accusation against you?
My lord, the accusation is that financial loss was there. Preliminary estimate suggests that the illegal activity is going on for some time, causing wrongful financial loss to the Brahmaputra Biochem Private Limited. So financial loss was done by us.
Who are you?
My lord, Parashmani Das is the, my lord, here the manipulation of company records and others, calling persons. My lord, manager is somebody different, that is Manoj Chaudhary. And
Who are you?
on further company reveals that they were doing all the planning guidance of Dipankar Kolita store manager. The main allegation was against Mr. Dipankar Kolita store manager. And I am staff of that, I was the staff, Nabo Mohanto and Parashmani Das. Allegations are under section 318, 316, 35 of the BNSA.
Yes. What happened there?
My lord, then my lord, the Caesar is at page. It is at page, my lord, 12. Caesar list. Dated 28/11/2025. FIR on the same data. FIR is also on.
What has been seized?
My lord, here it is written as one iPhone 15 mobile, then my lord, serial vehicle is also there, my lord, one Galaxy mobile number, and another is, my lord, your lordship, another page 14, another Caesar list where Mahindra Scorpio vehicle was also seized. on that is on 30/11, and mobile and others were seized on 28/11/25. And page 14, where my Mahindra Scorpio vehicle was also seized. And my lord, the rejection order, and on the same day, my lord, my bank account I have restated in para 4. It was seized and freezed. Para 4 I have stated, my lord. Account holder name, account number, name of branch, everything was given. Then, my lord, the rejection order is at page 16. Last few questions, my friend was there. As regards my lord, vehicle, they have no objection in pursuance to that Ambala judgment, my lord, 2003. But as regards the bank account, my lord, my submission was that, my lord, in between seizing and freezing, my lord, they have not taken the complied with 102 earlier and 106 now. The present. Huh? 1062. Earlier it was 102, now it is 1062. And my lord, as regards those, I have given 3 judgments which are there in the record. That is a mandatory provision which they have to comply with.
What is the requirement?
10 earlier 102, now my lord,
Yes, what was the requirement?
my lord, I'm pressing. 1062. 3. Every police officer acting under subsection 1 shall forthwith report the seizure of the magistrate before having jurisdiction where the property seized, in such that it cannot be conveniently transferred to the court, or where there is difficulty to secure proper accommodation for the custody of such property. They have to forthwith send it to the magistrate, and then on that order only they can freeze it. In between seizing and freezing, that provision has to be complied with. 1063, it was earlier 102. And as regards that, one judgment was there of the Gauhati High Court. It is there in the record, madam. Earlier also I have submitted 2022 6 GLR, page 772. You'll have to look into it. 2022 6 GLR, page 772.
Yes.
Para 8.
Yes. What it says.
Here in this case, it is submitted to the Land Council for the petitioner. The petitioner, due to such act of freezing of the bank account, had faced with hardship. The said hardship in my consideration is required to be taken into consideration even if the petitioner is charge sheeted. Moreover, the petitioner cannot be deprived of a subsistence allowance and the area salary deposited in the said bank account. Further, the bank account as held by Apex Court in Catena of decision is the property of the person against whom name the said account stands. So before freezing, it is mandatory to inform the jurisdictional magistrate once the police officer seized any property. A duty is cast under section 102 of subsection 3 CRPC on the investigating officer to report such act of seizure to the bank account pursuant to an investigation by the police, and while doing so, if any violation of 102, such seizures requires to be held as illegal.
Before freezing information,
To the magistrate.
where is that?
That is there, madam.
Statute,
A
where?
duty is cast under section sub 102.
No,
subsection
that is the observation in the, let us go to section 103.
Every police officer acting under subsection 1 shall forthwith report the seizure to the magistrate having jurisdiction, and where the property seized is such that it cannot be conveniently transported to the court.
Forthwith report the seizure. Report the seizure means after seizure you have to.
Seizure before freezing.
Where is that before
Well,
freezing?
that is clear from the Supreme Court in this judgment.
Which judgment?
My lord, 2024 7 SCC page para 20 page 23 para 26 27 from 23 onwards. Para 23 onwards. Even Gauhati High Court judgment has also said that.
Now you show me 2023 what it says.
From para 23 onwards.
Yes.
We are of the considered view The said expression must receive a reasonable construction. And in giving such construction, regard has to be had to the nature of the act or thing to be performed and the prevailing circumstances of the case. When it is not mandate the when it is not the mandate of the law, the act should be done within a fixed period. It would mean that the act must be done within a reasonable time. It all depends upon the circumstances that may unfold in a given case. There cannot be a straitjacket formula prescribed in this regard. In this sense, the interpretation of the word forthwith would depend upon in the terrain to which travels would take into color depending on the prevailing circumstances, which may be variable. Therefore, while deciding the police officers have properly discharged his obligation under 1023 CRPC, the magistrate would have to firstly examine whether the seizure was reported forthwith. In doing so, it ought to have regard to the interpretation of the expression forthwith as discussed above. It is fine that the report was not sent forthwith, then it must examine whether there is any explanation offered to in support of the delay. If the magistrate finds the delay has been properly explained, they would leave the matter at that. However, it is fine that no reasonable explanation for delay or the official has acted with deliberate disregard, wanton negligence, then it may direct for appropriate reprimandal action against such and such. Having clarified the above legal position, we may proceed to the question of facts. Then earlier, my lord, your lordship wants to know whether
No, but it does not say that prior leave has to be taken. It only says that intimation has to be given forthwith.
forthwith they have to give it. But that is not there in the report. They, for last four times they have not been able to say that they have been given. And on the report of the magistrate only, the bank can be can freeze the account.
Where is that?
Now that is forthwith, my lord, because the magistrate's order has to be there. The magistrate's orders has to be there. Even in this case, my lord, your lordship will find.
Apart from your submission, where is the support?
My lord,
The judgment which you are citing does
My lord.
not.
My lord, para 3, your lordship in this judgment of Gauhati High Court, my lord, your lordship will find in para 3.
Irina Kaur. Para 3.
Para 3. Yes,
Yes.
my lord. The learned counsel for the petitioner specifically raised an issue that the police official during the investigation failed to abide by the provisions stipulated under 102 of the CRP. As such, the action of freezing the SBI savings account of the petitioner illegal and liable to be defreeze the same. In view of the issue raised before this court, Mr. Pegu was directed to take necessary instruction from the concerned police officer as to whether there are any violation of the provision of section 102 CRPC. The respondent number 8, being the investigation officer, filed an affidavit while specific mention was made that the procedure under 102 could not be duly followed. Mr. B, in view of the submission made by the affidavit for direction to defreeze the bank account of the petitioner, the said pair is objected such and such. From the context of the body, it found that admittedly there is a violation of such and such of the 102 CRPC. Now, para 6. Section 102 of the CRPC stipulates that every police officer acting under subsection 1 shall forthwith seizure of the magistrate having jurisdiction where the property is seized is such that it cannot be conveyed and transported to the court. He may give custody thereof to the any person on his executing a bond undertaking to produce the property before the court. And when they are required to give the effect of further order of the court at the disposal of the same. Let us consider the effect of non-compliance of the provision of section 102. In a case of such and such, the court rejected the contention that non-compliance of the procedure laid down under section 10 CRPC is only an irregularity. It will not vitiate freezing of the bank account. It was held that in case of mandatory provision under section 102 CRPC, it has not been followed, then it would entail the consequence of giving direction to defreeze the bank account. The duty of reporting the magistrate any seizure of bank account is cast upon the IO as freezing of the bank account prevents the person from operating the bank account pursuant to investigation.
It only says that seizure of the bank account is to be reported.
Reported, then only there will be a.
Where is that?
No, that is what the contention comes from. If they, without the order of the moment it is informed to the magistrate, only on the order of the magistrate, the bank account will be freezed. Even that judgment, my lord, your lordship.
Till now, you are not able to show that what you are submitting.
But the judgment itself shows that the freezing.
No, that I am repeatedly asking. Show me from the judgment where.
Yeah, in para 6 only in the Gauhati High Court judgment, that it has said that freezing, the word freezing is there. My lord, your lordship will find that, now.
We will continue at 2.
Yes, Your Lordship. Item number 13, kindly absent for today, Lordship. Part of matter. Opposite purchase.
Your lordship, we are under pressure in this matter, both
What pressure?
for lordship from the clients and the agency, so.
Pressure from whom?
Please stop that, please.
We fix on next week.
I see. Heard Mr. M. Alamgir, learned counsel for the respondent, appellant, who prays for an adjournment due to why?
Lordship,
Reason for adjournment?
colleague will argue the case, he is not available.
Adjournment for the personal difficulty on the part of the conducting counsel for the appellant. Learned counsel for the respondent, though agrees to the submissions, though agrees to the prayer, however, has prayed for fixing a short date for the same. The prayer is allowed. 23rd June. Let this matter be listed on 23rd June.
I beg to mention item number 15 and 16, lordship.
15 and 16.
The conducting counsel, Mr. I has some personal difficulties, lordship. He was here in the first half, lordship.
Respondent number?
Respondent number, lordship.
Or respondent?
On 15, lordship, we are for appellant side.
Miss, what is your name? You have informed the other side. You have to inform before me. You inform, we'll allow you, but not now. After you inform the other side, only then you can have to make mention, not at their back. So wait for your turn. We'll allow adjournment, but we'll not pass order now. Okay. Yes, Mr. Rajode.
My lord, the query that
The
your lordship,
difference between freezing and
My lord,
freezing.
I have gone through, my lord, your lordship's query was absolutely correct. My lord, I placed the submission in that way. Seizure is bad if it is not forthwith sent to the magistrate about the seizure.
Yes.
That is bad. That I will place the submission in that way.
Oh, there was a delivery of judgment. Just a minute, just a minute. I have to deliver one judgment. No, Putul. Itu corrections হয়েছে আমি deliver করে দেব।
Item 28, delivery of document.
The appeal is dismissed and the maintenance awarded, the compensation awarded to the claimant by the tribunal is kept as it is. It is upheld. Yes.
Well, my submission is this, my lord. Here, the seizure, the word is 1063, earlier 1023, forthwith. And the forthwith, the explanation given in the recent judgment also in 24/7 SCC 23, which has been relied on in a 25 judgment delivered on 10th December 2025, where also it has said that if there is a delay, the explanation has to be given.
Yes.
My lord, here my submission is this: they have not complied with the provisions that is left out. And as regards mobile phone, vehicle, and others, my lord, I rely on the 2003 judgment of Ambala, my lord, where within 15 days they had to release it. My lord. That is, my lord, Sundar Bhai Ambala.
Vehicle have been released,
No, my lord, nothing else.
but they are not opposing.
They are not opposing to a ballot. It may be done, but they are opposing to the extent of defreezing the bank account.
Okay.
I
And
think my friend is there.
bank account, what is your submission that it was not, where is, when the Caesar memo was?
28 on the same day. The Caesar memo only shows about my lord, my mobile phone and others.
No, when it was intimated to the court.
My lord, there is nothing, my lord, because Caesar list itself shows that.
You have the case diary. Okay, okay. Your submission is that it was not
On that same day. because-
reported forthwith, therefore it is bad.
On 28/11/25, the affair is dated, my lord, 28, my lord. Affair is dated, my lord, 28/11/25, and on the same day, my lord, the Caesar was done.
When it was reported,
My lord, reported, my lord, I don't know, my lord, my submission is this, that it was not at all reported. And it was, if at all, my lord, it was quite a delay. I don't know, my lord, that is.
yes, Mr. Loka.
As per CD lordship, on earlier occasion also I submitted. That CD, I have not found any letter intimating the court that these articles has been neither prior to the CD or freezing.
Prior to seizing is not law,
Then after seizing.
but after seizing you have to inform. Otherwise it is bad.
That is not there. Then I asked the IO concerned. Then he subsequently he is being entrusted with this case. And he has he told me on verbal instruction, he told me that there was that intimation was not given to the
Then it is liable to be quashed.
Therefore,
Third, Mr. P.K. Roy Chaudhary, learned senior counsel assisted by Miss R. Roy, learned counsel for the petitioner. There are two cases. Why?
Two different persons, the vehicles and mobile phone and the bank accounts are different. Same affair, two different persons.
And Caesar list?
Caesar list, my lord, here also, the Caesar list is. My lord, type copy of the Caesar list, page 12. Here also, my lord, the names are different, but the vehicles are different. Here in the second one, Novo Mohanto, page 12, and my lord, page 14, the Caesar list.
Second case. क्या लिखा? So and so. Also Mr. P.S. Locker, London, additional public prosecutor. By this common judgment, this court intends to dispose of two criminal petitions, namely criminal petition number 236/2026 and 237/2026, which has impugn order is same.
In order in the second case is at page 16. 12/1/26. Date is same.
Page 16.
An earlier one, the second case is the Innova. The first case is, my lord, it was Scorpio. Date is same.
In both the petitions, order is a common order. Impugn order.
Impugn order date is same, my lord, but the applications were filed differently.
But order has been passed, common order.
In page, your lordship will find it. This is
Inside
Innova
that.
Vista. In the second case, it is written as one Innova.
Okay,
Vista.
okay.
And in the first case,
Yeah,
it is Scorpio.
okay. which has impugned order dated wherein two separate orders passed in Palaswari PS case number 368/2025 on 12/1/2026 have been impugned. In the criminal petition number 236/2026 by the impugned order dated 12/1/2026, prayer for grant of Jimma of seized vehicle bearing registration number AS04BC9602 within bracket 1 Innova Krista, one Google Pixel 10 Pro mobile and defreezing of bank account was rejected, whereas in line to products last line. Stop. Impugn or episode stop. In the criminal petition number so and so. Read. In the criminal petition number 236. Now read. Has been impugned. Rejected has been impugned. Stop. Whereas in the criminal petition number 237/2026, the order dated 12/1/2026 passed in Palashwari PS case number 368/2025, whereby the prayer for grant of Jimma of vehicle bearing registration number AS01FV4308 within bracket one Mahindra Scorpio vehicle bracket close, one iPhone 15 mobile and defreezing of bank account of petitioner Parasmani Das was rejected has been impugned. Since as both the impugned orders were passed in connection with Palaswari PS case number 368/2025. Hence, the criminal petitions are taken up for hearing together and are disposed of by this common order. Stop. Next panel. The facts relevant for consideration of the above mentioned criminal petitions are, in brief, that on 28/11/2025, 1. FIR was lodged before the officer in charge of Boko police station. How Boko police station? The case number is Palaswari case.
But it was within, I think, it has been transferred to ML. On that basis only, my lord, I was given anticipatory bail also. Interim.
Now, how it came to Palaswari? The case is FIR. Mr. Locker, go through the FIR.
Boko PS case. Was registered under
Fair lost before Boko police station. And I received the CD from Boko.
Boko. Then how order is passed in Palaswari police station case? Impugn order has been passed in Palaswari PS case number. There is
number is Boko 368.
no whether it is Palaswari or
It's Boko loss.
it cannot be Palaswari.
It should be Boko.
Because as I had lost before Boko and I have received the CD from the Boko itself.
You may be typing well or wrong, right? It should be fine.
Yes.
Boko police station.
But it is in the morning Boko now. District Boko Kandur, page 18.
In Navamahanta case, it is
Boko. In Porashmani also it's Boko. My lord, typing may be wrong, my lord. It should be Boko.
Oh, it is Boko. You have typed wrongly.
Type. Fine. It should be Boko.
Well, in place of Palaswari, write Boko police station. Last line किया सीने. Of Palaswari, Boko police station, inter alia, alleging that the accused persons named in the said FIR have indulged in theft, cheating, criminal breach of trust, and criminal conspiracy, causing wrongful financial loss to the Brahmaputra Biochemical Private Limited. Stop. On receipt of the said FIR, Boko PS case number 368/2025 was registered under section 318 within bracket 4/316 within bracket 4/3 within bracket 5 of BNS. An investigation was initiated. During the course of investigation, the vehicle which is the date of seizure? 30/11, same date.
28. Caesar is one page 12 in case of Porashmani. The iPhone and others on 28/11 and vehicle on 30/11. Page 12 and page 14.
Stop it. He told during the course of investigation, the iPhone and one iPhone of the petitioner in criminal petition number 237/2026, namely Parashmani Das, was seized on
And another mobile is there, one Galaxy Ultra mobile, number 2.
iPhone as well as one Galaxy Ultra mobile of petitioner in so and so was seized on 28/4/2025,
28/11.
28/11/2025 at 9 p.m. And thereafter, one Mahindra Scorpio vehicle bearing registration number AS01F VFV 4308 was seized on 30/11/2025. Similarly, the
Your Lordship's permission, page 4 in Parashmani Das, paragraph 4, the bank account, everything details has been given.
there is no seizure list.
No season, the bank account and other things has been given.
How you came to know that your bank account has been seized?
Because when I have not been able to operate it, the bank is there. I have given a statement in para 4.
Similarly, the bank account of the petitioner Parasmani Das was seized, was freezed by the investigating, by the bank in connection with the aforesaid case. On which date it was freezed, it is not there, no? By in connection with the aforementioned case. Stop. In a similar manner, the Innova Crista vehicle bearing registration number AS04BC 9602 belonging to the petitioner of criminal petition number 236/26, namely Nabha Mahanta, was seized on 30/11/2025, and one Google Pixel mobile handset was seized from him on 28/11/2025.
And para 4, my lord, the bank account is been given.
His bank account bearing account number 50100216632551 of HDFC Bank Vijayanagar was also seized in connection with the aforementioned case.
2 bank account, other bank account, the 395, such as.
Stop. Another bank account of Vijay Mahanta,
Should be SBI.
Nava Mahanta, bearing number 395770120
SBI Boko.
in SBI
Boko.
Boko branch was also seized in connection with the aforesaid case. Both the petitioners approached the trial court seeking jimma of the seized articles, as well as praying for defreezing of their respective bank accounts. However, by impugn orders dated 12/1/2026, the prayer for jimma, grant of jimma, was rejected by the trial court. Grant of by the trial court, considering the stage of investigation at which the investigation was pending at that point of time. Stop. Mr. P.K. Roy Chaudhary, learned senior counsel for the petitioners in both the criminal petition, has submitted that under section, what is the new? Under section 106(3) of the BNSS, 106 within bracket 3 of the BNSS, in event of seizing of any property in connection with a case, the investigating officer is duty bound to forthwith report such a seizure to magistrate having jurisdiction where the property having jurisdiction. Stop. He submits that in the instant case, the freezing of bank account, which also amounts to seizure of a property under section 106 of BNSS, was not even reported to the jurisdictional court. He also submits that the vehicles seized in connection with the above mentioned police station case are lying in the police station campus since the date of their seizure for last about 6 months. And as per the guideline of the apex court in Sundar Bhai, you are relying?
That is 2003 AIR
Apex court in the case of Sundar Bhai Ambarlal Desai versus stay.
AIR 2003 Supreme Court 638.
Versus state of Gujarat reported in so and so. The vehicles seized, the apex court has deprecated the practice of retaining the vehicle in the police station campus for a long period. He submits that the petitioners are ready to cooperate in the investigation and produce the seized vehicle as well as mobile as and when required for the purpose of investigation or trial. He also submits that since the freezing of the bank account is in violation of the provisions contained in section 106 clause, which clause?
Plus 3, ma'am.
Clause 3 of within 106 within bracket 3 of the BNSS. The freezing of bank account no calical lastly. So he also submits that the apex court in a catena of decisions has held that the property of person against whose name the accounts stand no. He also submits that the apex court has held that the bank accounts may be regarded as property of persons against whose name the accounts are held, and hence it is mandatory to inform the jurisdictional magistrate once such bank account are freezed, and any violation thereof would make the such a freezing illegal, and hence he prays for defreezing the bank account immediately. In support of his submission, learned senior counsel for the petitioners has cited following rulings. Number 1, number 1, Shento Varghese versus Julfikar Hussain and others, reported in 2024 7 SCC 23. Next, Irina Kumar versus State of Assam and others. What is this Anil Kumar Day?
Here, the fourth tweet has been clarified, ma'am,
Right.
relying on 24/7.
Number 3, State of West Bengal versus Anil Kumar Day within bracket criminal appeal number 5373/2025.
Judgment dated 10 December 25. Last page.
Judgment dated 10 December 2025 of the Supreme Court of India. Bracket close. Yes, Mr. Lakar, what is your stand? I started dictating without hearing you.
Lordship, that I have gone to the city lordship, and in city lordship, I have not found anything regarding that intimation to the.
Yes, yes.
And I have inquired it to the IO also, and IO informed me that that has not been.
Regarding bank freezing,
Bank-
but regarding other seizures,
Others just lordship,
the seizure memo has been shown to the judiciary. No,
that is
that is there.
that is-
That endorsement, scene endorsement is there. So what is your submission regarding his prayer for defreezing? Whether you require, whether I require.
As per the IO report, that is required. They have stated also as per their requirement, it is required for them also. But I leave it to also. In the vehicle with the IO. Because those are not actually what in statement, through the statement it reveals also that those are procured from that he has.
Proceeds of crime. Only therefore it is required. On the other hand, Mr. P.S. Lakar has produced the case diary of Boko PS case number 368/2025 and has fairly submitted that as regards the freezing of the bank account of both the petitioners are concerned, no intimation to that effect was given to the jurisdictional magistrate by the investigating officers. However, as regards other seizures, same was done by the investigating officer. He submits that he has procured a report from the investigating officer of the case as was directed by this court, and same is placed with the case record. He also submits that as regards the grant of Jimma of the other seized materials are concerned, like vehicle and mobile phones, the same is objected to mainly on the ground that those vehicle and mobile phones are suspected to have been procured from the proceeds of crime. He also submits that the investigation of the case is still going on. You are opposing or not? Still going on. And therefore he opposes the prayer for grant of Jimma of the seized materials. Stop. I have considered the submissions made by learned counsel for both sides and have gone through the materials available on record. I have also gone through the case diary of Boko PS case number 368/2025. as regards the impugn orders dated 12/1/2026 passed by the learned Judicial Magistrate First Class Boko are concerned, it appears that the prayer for grant of Jimma made by the Jimma of the seized properties made by the present petitioners was rejected considering the stage of investigation, and no further reasoning was given in the impugn orders. Stop. Now it appears that more than 5 months have lapsed since the date of passing of the impugn orders, and it also appears that the vehicles in questions, vehicles which are seized in this case, are lying under open sky in the police station campus. The apex court has observed in the case of Sundar Bhai Ambalal Desai versus State of Gujarat within bracket Supra that it is of no use to keep seized vehicles at police station for long periods, and it is for the magistrate to pass appropriate orders immediately by taking appropriate bond and guarantee as well as security for return of the said vehicles if required at any point of time. Stop. In view of the observations made by the apex court, as well as in view of the fact that the vehicles are lying under open sky for about last more than 5 months, and that the petitioners are ready to cooperate in the investigation and produce the said vehicles as and when required. The impugn orders are interfered with, and the investigating officer of POCO PS case number 368/2025 is hereby directed to give the vehicles of the petitioners what is the proof which you have furnished RC?
My registration card, everything.
And regarding mobile phones,
My phone, my lord, cause
how will you prove the ownership?
the receipts of purchase.
Uh, last line. Vehicles of the petitioners seized in the above noted case by on their furnishing a bond of rupees 15 lakhs against each of the seized vehicle, and also furnishing a bond of how much against the
Own, my lord, owns
bond of 50,000 for production of the seized mobiles as and when required. At the time of giving the Jimma, the photographs of the vehicles and phones shall be taken by the investigating officer. The investigating officer shall also prepare one inventory and tag the same with the Jimmanama to be kept along with the case record of Boko PS case number 368/2025. As regards the freezing of bank accounts mentioned herein above of the present petitioner is concerned, since no intimation of the same was given to the jurisdictional magistrate in terms of the provision contained in section 106 within bracket 3 of BNSS. Such freezing of bank account is bad in law, and as such, same is defreezed. The concerned bank managers are directed to defreeze the same account, said accounts. Anything else? With above observation, these criminal petitions are disposed of. Send back the case diary along with a copy of this order to the investigating officer.
On submission is there. Item number 21, my lord, today already there is an alarm of a heavy rainfall and
Yes.
my lord, I think my lord, it will not reach also. I think.
This alarm came to everyone's phone.
Everyone. The huge alarm has come to everyone. There will be. So can.
So everything should be adjourned.
No, my lord, my item may be fixed on 11th, my lord. My lord, I have talked to the other side also.
Yeah. On request of item number?
Okay. Not on request of mine, my lord, my lord, because maybe a paucity of time also, my lord, because it will not be, because my lord, adjournment might.
Okay, when do you want?
To 11th, my lord, 11th June. Thursday.
16th. Let this matter be listed on 16th. Heard Mr. P. K. Roy Chaudhary, learned senior counsel assisted by Miss R. Roy. Also heard Miss O. Gupta, learned counsel for respondent number 2. Due to paucity of time, this matter could not be taken up for hearing. Let this matter be listed again on 16th of June.
All right.
Item A.
Wait, please, Your Lordship. Lordship, this is an IA for suspension of sentence. I was convicted under section 451, 376, 3, 511 of the IPC, along with section 18 of the POCSO Act. And I was sentenced for 10 years of imprisonment.
POCSO,
10 years imprisonment.
the other side, victim is there. Okay.
And Your Lordship takes up the FIR.
Oh. On what ground you are seeking bail?
My lord, her statement is, her evidence is that I broke open the house from backside of the house.
July. Please take it.
Item 10.
Yes.
Ballot. This is for interlocutory application for the suspension of sentence, my lord. Here, what happened initially, my lord, this petitioner, before your lordship, he was acquitted in the trial by the trial court.
Acquitted.
Yes, acquitted in a charge of 376 because the statement of the victim as per the judgment, my lord, is not trustworthy. And there is a delay of 11 months in the lodging of the FIR.
Who is appearing for the victim?
In whether the third party.
376, my lord. It's not a POSCO, my lord.
But in 376 also victim has a right to be heard.
Well, that is on the final hearing. That is for the final hearing. They have the, it's not mandatory. There's a judgment of the
30 of BNSS 2023 has been filed by the applicant Dhananjay Chauhan in connection with criminal appeal number 255/2025, praying for suspension of sentence imposed on him by the judgment impugned in the connected appeal. During the pendency of the connected appeal. Stop. On perusal of the interlocutory application, it appears that though the state is made a party respondent in this case, the victim girl has not been made made a respondent. In view of this court is of considered opinion that the victim has a right to be heard in this interlocutory application as well as in the connected appeal. Should we issue notice or
yeah, my first lordship possible.
hence list recondio amicus hence to defend the cause of the respondent number 2, this court is inclined to appoint one amicus curiae. Accordingly, accordingly, Miss M.K. Brown, whose name appears in the list of amicus curiae, is hereby appointed as amicus curiae to defend. In this case, the applicant/appellant is directed to furnish copy of the memo of appeal and the interlocutory application along with annexures to the newly appointed amicus curiae within how many days? Within 3 days from the date of this order. List this matter 16th of June or after 23rd. List this matter again on 23rd of June.
In appeal, my lord, notice has to be issued. In appeal.
Yes, in appeal. Appeal also, same order, we appoint. She will try to contact the victim because 376 victim will not come otherwise.
Obliged.
Item 11.
May please the Lordship.
So
So
I-
I for suspension of sentence, my lord, as well as the bail during the pendency of the application, my lord. The applicant has been convicted under section 354B as well as section 10 of the POCSO Act. And
considering the facts and circumstances of this case, instead of taking up the interlocutory application for consideration, this court intends to hear the appeal and finally dispose of the same on a fixed date. Accordingly, let this matter be listed for hearing 16th of July.
Prabhu maybe furnish and appellant also was.
The registry is directed to the you have received directed to furnish a copy of paper book to the learned counsel for the PP has received
Seen an endorsement here, that's in the office note.
to the appellant as well as respondent number 2 before the next date of hearing.
Item 15.
There was an adjournment prayer. An adjournment prayer was made.
One more thing, he mentioned on my behalf because I have the second half. And there are two appeals that are the same judgment. One, we are referring the appeal, that is item number 15, it is against the conviction under section 417, my lord, whereby the appellant has been convicted for 3 months and fine also. And in the other appeal, they have come for enhancement of the sentence under section 372, my lord, they have filed their appeal.
Who is appearing for them?
There is some other,
Respondent number 2
Counsel
is
is there.
appearing for the petitioner in item number 16.
so in that appeal also, we are not there. Suppose we are supposed to be there in it for the present appellant, only 15. But some other advocates also are not here, so they will be required to hear because there are lots of their other appeal is against for enhancement of the sentence they are coming. And that's up to lots of, otherwise it's a very old matter, my lord. Occurrence of 2013 and petitioner will convicted for 3 months. In the meantime, during the trial investigation, he had already was arrested and already spent 1.5 months in jail. And left 1.5 months left only. That's left.
1.5 months left.
Only. There is, I've got this. He was arrested.
Now what should we do?
Respondent number 2 is not here.
Who is appearing for them?
May seek, Lord.
Amishi. Heard Mr. I.A. Hajorika, learned counsel for the appellant. Also heard Ms. S.H. Bora, learned additional public prosecutor. None has appeared for respondent number 2. Since the respondent number 2 in this appeal has filed a connected appeal, that is criminal appeal number 314/2015, praying for enhancement of the sentence imposed on the present appellant.
Victim man. I was a victim.
Yes. Hence, the presence of respondent number 2 counsel, presence of the counsel for respondent number 2/victim. No. And since both the appeals are connected appeals and are to be heard together, the presence of learned counsel for respondent number 2 would be desirable at the time of hearing of this case appeal. Hence, this matter is adjourned for the day. Let this matter be listed of July tata date deo. 21st July.
Item 17.
Yeah, if my senior is a legs, some other day next week.
Heard Mr.
Hey, Bolwa.
A. Borwal, learned counsel for the petitioner, who prays for a short recommendation as the counsel for learned engaged counsel for the petitioner is on legs in a different court. Also, Mr. M.P. Goswami, learned additional public prosecutor. The prayer is allowed. Let this matter be listed after 2 weeks from the date to be fixed by registry.
Finally, date is
July. 23rd July.
probably.
Item 23.
Petitioner in person. Supposed to appear on behalf of the other side, so please.
What is the matter?
It's criminal petition regarding quashing of the FIR. Dated 4/3/2023.
Okay, we'll adjourn it. Weather alarm is there today. Bad weather.
Yeah. That's allowed.
None has appeared for the petitioner on call. Ms. S.H. Bora, learned additional public prosecutor is present. Let this matter be listed after 2 weeks on a date to be fixed by registry.
Item 24.
None has appeared for the petitioner on call. Ms. S.H. Bora, learned additional public prosecutor is present. Let this matter be listed again after 2 weeks on a date to be fixed by registry.
Item 25.
Yes.
Your Lordship, it's a matter, it's that the petitioner is absent. They are not appearing right now, but it is a delay condonation that has been challenged by the petitioner. There is a delay of 12 days, according to the calculations, but they are seeking delay of 5 days only. Your Lordship may kindly see the, if your Lordship may please, then I can just
Now, why this revision petition was?
sought by them against the order passed by the additional district and session judge number 3, whereby they preferred a delay condonation of 5 days.
In filing what?
Criminal appeal.
And that was not allowed.
It's not allowed. Whereas, according to the calculations, there was a delay of 12 days. The impugn or judgment and order was passed on 12/6/2024.
Today, they are not present, we cannot hear. No one has appeared for the petitioner on call. Heard Miss, what is her name? R.R. Muzib, learned counsel for respondent number 2. Miss S.H. Bora, learned additional public prosecutor, appears for this day. Let this matter be listed again on 23rd July. The interim order shall continue till next day. What interim order was passed?
Order was stayed. That's conviction order was stayed. Your lordship,
No interim. Interim to continue. Nothing as regards interim.
Item 26.
Petitioner in person. Yes, Mr. Sen.
My lord, may I pray for a short accommodation due to my lord the.
Yes, yes.
My lord, because-
On request of learned counsel for the petitioner for a short accommodation, which is not objected to by learned additional public prosecutor Ms. S.H. Vora. This matter is be listed on 21st July.
After vacation.
I'm sorry, Lordship. Item number 25, Lordship. I was downstairs, I was on the way, but already order has been passed, Lordship.
Now, what is your submission?
If Lordship will take up, and also Lordship on earlier occasion, this matter was extensively heard by Honorable Justice S.P. Khan, Lordship.
So let it be on your interim. Is there any interim order?
Yes, yes.
What interim order?
Lordship, the operation of the impugned judgment passed by the London Trial Court has been.
Impugned judgment is not condoning the delay.
No, the order I have said in Lordship for not condoning the delay. But while issuing notice, this honorable court was pleased to state the operation of the impugned judgment passed by the London Trial Court. Because Lordship, otherwise, if that judgment was not suspended,
Then it is required to be heard. And then we will give a short date. কিমান আছিলে? Before vacation. Before vacation attending you. 23rd June. The interim order shall continue till next day.
Deeply.
Item 27.
Yeah, my lord, we have challenged the entire proceeding of the POSCO case, ma'am. On the last occasion, your lordship was pleased to appoint one amicus curiae. It seems he is not here today, ma'am. So can it be some other day or lordship's convenient, ma'am? No stay, nothing is there.
Okay. Heard Mr.
But
J.I.
I'm not seeking adjournment, ma'am. You're there because.
Heard Mr. J.I. Barboya.
Informant, amicus curiae.
J.I. Barboya, the learned counsel appearing for the petitioner. Also heard Ms. S.H. Vora, learned additional public prosecutor. It appears that by order dated 23/4/2026, Mr. D. Ullah was appointed as amicus curiae by this court to represent the respondent number 2. However, Mr. Ullah is not present today. Hence, the matter is adjourned for the day. Let this matter be listed. What is the matter actually? Quashing the POCSO bill.
Proceeding, because only basing on the hearsay evidence case is going.
Passing of the FIR as well as.
FIR as well as the
Charge sheet.
proceeding, entire process.
Trial is going on. Let this matter be listed 28th July.
Lordship, I am for 23. Lordship, I am for 23, Lordship.
Just a minute. Show the presence of Mr. Ullah, we have given a date.
Lordship, I am for 23, Lordship.
Where were you when the
Please,
matter
Lordship.
was called?
Lordship, it was an internet connection problem, Lordship. Lordship, kindly 1 second hear me, Lordship.
Yes,
But did this.
Lordship, issue is, Lordship, that in the last order, my lord, counter affidavit was said to be filed, but till now, no counter affidavit has been filed by the respondent number 2, my lord, that is private party. And Lordship, it is pending from 3.5 years, my lord, matter. So kindly, my lord,
No,
a
just
fixed
a
date may
minute.
be given.
Mr. Pathak, please wait.
Lordship.
Who is appearing, Miss Ajoy Bora? Who is appearing for respondent number 2?
Mr. S. Rahman. And Mr. U. Pandey. And A. Mistral also.
We are giving a short date.
Lordship, a fixed date may be given, Lordship.
Yes.
Lordship, I humbly request, my lord, that 3.5 years has been there, my lord, no counter was filed. And all of a sudden they appeared at the last date and requested to file counter affidavit. But Lordship, much time was given. 3 weeks time was given, and now Lordship 1.5 month has been elapsed. No counter has been filed. My lord, kindly final disposal, my lord, in fixed date may be given, my lord, so that it may be finally disposed of.
Heard Mr. Chandan Pathak, the petitioner in person appearing through video conferencing. Stock also heard Ms. S.H. Vora, London additional public prosecutor, appearing for the state respondent. None has appeared for respondent number 2. On perusal of order dated 28/4/2026, it appears that the respondent number 2 was granted some time to file written objection in this case. However, no such objection has What is the matter?
Matter was related to, my lord, quashing of an FIR under section 376 of IPC, my lord.
What is the status?
Status is, my lord, it is pending before the trial court and it is stayed, my lord, from 2024
Whether
August.
charge sheet has been laid?
Yes, Lord. So charge sheet has been laid, and by way of additional affidavit, charge sheet has been challenged also on record also, my lord.
And whether is there any stay?
Yes, Lordship. Stay order is there, Lordship. Kindly continue the interim stay till Lordship final disposal, Lordship.
No, whether any stay has been granted?
Yes, Lordship. By this honorable court, on 12/8/2024, stay was granted, my lord.
When?
When it was granted.
When the stay was granted?
12/8/2024, Lordship.
Okay.
Order dated 12/8/2024.
Last line. However, office note dated 30/5/2026 shows that the respondent number 2 has not yet filed any written objection. Stop. Considering the nature of this case, one last chance is granted to the respondent number 2 for filing written objection. Stop. Accordingly, let this matter be listed on 28th July. Listed.